strict liability. An intentional tort is a wrong that was done with intent, meaning they intended or meant to do it. Somebody's getting beat up in there. Erin, you okay? All right. There are several types of intentional torts. There's assault. You guys have probably heard of these. I don't know. We might be experiencing something. Erin's got something going on over there. So assault is the threat of immediate harm or offensive contact. Any action that arouses reasonable apprehension of imminent harm. Actual physical contact is not necessary for assault. For example, let's say I'm a 5'2" girl, I'm in baggy clothes, and I'm threatening a 6'6" guy. By clenching my fists and raising them at him, is that threatening? Should he feel threatened? He's bigger than I am, right? But what if that girl that is in baggy clothes isn't showing her true self? She's in baggy clothes. What if she's actually a professional fighter? Now, should he be scared? Probably, right? Battery. Battery is unauthorized and harmful or offensive, direct or indirect physical contact with another person that causes injury. So, for example, I told you guys before that I used to live in Las Vegas. And one day I was driving, running errands at lunch or whatever. I was driving down the road and there were two guys that were just off the road and they were fighting. And they actually picked up some of the river rocks that were used as landscape or used on the landscape as decoration. They grabbed those and started beating each other with them. It was frightening. But would that count as battery? It's not a gun, right? But could assault charges be brought up as well for that kind of a situation?
Yeah, I would imagine some harm came to them from that. So yes.
Yeah, for sure. And assault, just threatening them with the rock, right? That could have been assault. But then
wouldn't that be assault with a deadly weapon?
It could be. It could be. Yeah. I mean, because the rock could do some serious harm.
If you hit somebody hard enough, you can kill them with that.
Yeah,
for sure.
Absolutely. So, and it depends on where you hit them too. If you hit them in the head, they may not have a chance, right? So let's change.
Somewhere along the lines, wouldn't that be attempted murder too?
Yes, absolutely. It could be, for sure. They could bring charges against them for that. And then of course, when they go to trial, they would have the opportunity to possibly have the opportunity to go before a jury, and the jury would make that determination of what actually seems beyond a reasonable doubt, right? So let's change that example up a little bit. And let's say that there were 3 people involved, because there was a woman there. It was a woman and 2 men. And the woman is watching in horror as this attack is going on. The one guy picks up the rock and picks up another rock to throw, and the other guy ducks, and the rock hits the woman. So it knocks her unconscious. So do you think this, and that was kind of made up. I mean, that didn't really happen, at least not that I saw while I was there, but that could have happened. And does that still count as an intentional tort?
He intended to hurt somebody.
He intended to hurt somebody. Very good. So yes, it does. So the transferred intent doctrine allows the law to be transferred from the target to the actual victim. So in this case, it's transferred from the person that he was actually throwing the rock at and the person that it actually hit. So if you intended to hurt one person and you actually hurt another, that could still fall under an intentional tort. False imprisonment is the intentional confinement or restraint of another person without authority or justification and without the other person's consent. If you are arrested, is that false imprisonment?
No.
No, it is not. because there is a person of authority and they have justification, right? Shoplifting is an act that causes substantial losses to merchants. Most states have what's called the merchant protection statutes, and that allows the merchants to stop, detain, and investigate suspected shoplifters without being held liable for false imprisonment. If there's two things, if they have reasonable, or more than two things, if they are reasonable grounds, if they're detained for a reasonable time, and if the investigations are conducted in reasonable manner. I'm so sorry. Do you guys hear my dogs?
A little bit.
I have extras today. My daughter's dogs are over too. So I've got 4 dogs here and it gets a little crazy. So I apologize.
So
Let's take a look at
there's
case
also,
5.1.
that was also a tort though?
I'm sorry, what?
The theft is also a tort?
Yes.
Okay.
Let's take a look at page 5 or case 5.1. I'm not sure what page that is in your book. It's Walmart Stores Inc. versus Cockrell,
What page is it on your book? I have your book.
119.
Mine starts on 87.
Thank you. Okay. Carl Cockrell and his parents went to the layaway department at a store owned by Walmart Stores Inc. Cockrell stayed for about 5 minutes and decided to leave. As he was going out the front door, Raymond Navarro, a Walmart loss prevention officer, stopped him and requested that Cockrell follow him to the manager's office. Once in the office, Navarro told him to pull his pants down. Cockrell put his hands between his shorts and underwear, pulled them down, and then shook them. Nothing fell out. Next, Navarro told him to take off his shirt. Cockrell raised his shirt, revealing a large bandage that covered a surgical wound on the right side of his abdomen. Cockrell had recently had a liver transplant. Navarro asked him to take off the bandage, despite Cockrell's explanation that the bandage maintained a sterile environment around his surgical wound. On Navarro's insistence, Cockrell took down the bandage, revealing his wound. Navarro let Cockrell go. Cockrell sued Walmart to recover damages for false imprisonment. Walmart defended, alleging that the shopkeeper's privilege protected it from liability. The trial court found in favor of Cockrell and awarded Cockrell $300,000 for his mental anguish. Walmart appealed. So the issue in this case is, does the shopkeeper's privilege protect Walmart from liability under the circumstances of this case? And the court said, Navarro claimed he had reasons to suspect Cockrell of shoplifting. He said that Cockrell was acting suspiciously because he saw him in the women's department standing very close to a rack of clothes and looking around. We conclude that a rational jury could have found that Navarro did not reasonably believe a theft had occurred and therefore lacked authority to detain Cockrell. Now, Navarro's search was unreasonable in scope because he had no probable cause to believe that Cockrell had hidden any merchandise under the bandage. Removal of the bandage compromised the sterile environment surrounding the wound. The Court of Appeals upheld the trial court's finding that Walmart had falsely imprisoned Cockrell and had not proved the shopkeeper's privilege. The Court of Appeals upheld the trial court's judgment that awarded Cockrell $300,000 for mental anguish. So what do you guys think about this? Did Navarro, the Walmart employee, act responsibly in this case?
I think he jumped to conclusions.
He did. He might have been profiling, possibly.
Mm-hmm.
I mean, the guy was just standing in the women's department. He didn't see him put anything under his clothes or any of that. But he was acting weird, he thought. But that's all kind of, you know, up to the eye of the observer. Some people I see act like they're looking or look like they're being weird or something, but maybe I see it that way and someone else wouldn't.
Does it
Well, if it was a guy in the women's clothing aisle, then that's kind of suspicious. And if he's alone, if he's with the woman, that would have been a different story.
Well, I don't know. I mean, yes, I agree that that could be suspicious, but on the other hand, what if he was married and his wife asked him to go pick up something from the women's aisle? That could be too. Or maybe his mother asked him to get him something, or he was shopping for a woman. So that's not quite, I mean, I could see where it'd be a little bit crazy if he's just standing around there, but if he looked around and he didn't see what he needed and he walked out, that would be different, right?
I agree with that. But when I go to shopping with my girlfriend, she wanders off and I'm standing there, then I feel a little embarrassed. So I try to look around too.
There
Does,
you go.
does,
Okay, so did Walmart act ethically in denying liability in this case?
I mean, it depends. Does a private entity, theft prevention officer have the authority to detain people?
So he did. So what it says for this, the merchant protection statute is that if there are reasonable grounds, they are detained for a reasonable time and the investigations are conducted in a reasonable manner. Do you think it was reasonable to ask to take the bandage off?
No.
That seemed unreasonable. No.
What could he have hid under that bandage, right? I mean,
That'd be pretty hard to put clothes under a bandage.
yeah.
Right?
Well, I think it's inappropriate to have somebody take their clothes off as well.
Yeah,
Yeah.
I feel like if you're to that point, like you can maybe call the cops and have them proceed and be like, hey, this person was suspicious, but like to go that far as a Walmart employee just as shoplifting prevention, I think is overstepping.
Yeah, I don't think anybody who's like in that position has any authority like past like calling the cops. In my opinion, like I even think like the searching is a little suspect. Like just in, I don't know. I just don't feel like that's anyone's job, but like someone with the authority to like enforce the law.
In 2013, my friend was shopping at the Basement, which is like a clothing store downtown, and they thought that she stole something, and they asked her to take off her shirt to see if she was like wearing another shirt under it, and she wouldn't do it, but she didn't sue them, but they like asked her to at least like lift it up to her midriff. So I don't think it's that uncommon that people will try and overstep their boundaries.
I'm sorry about that. My dogs got a little crazy. So yeah, I did hear the part where the cops may have been an option for them to bring in, and I think that's probably true. And Annalisa, I'm sorry, I missed some of what you were saying.
I was just saying that at a store here in Flagstaff in 2013, one of my friends, they thought that she was stealing something and they asked her to take off her clothes as well, which seemed like really inappropriate. She didn't do it. And I mean, but I think that people definitely try and overstep their boundaries and get kind of carried away with their limits.
Yeah, I agree. It can be a little bit crazy sometimes. And, it just depends on the situation and how that shopkeeper or the loss officer, how they were told to conduct themselves as well. Maybe Walmart's policy is that they have them take their clothes off, which I doubt. But the fact that Walmart was behind him and said, no, this is the way that it should have been, that also could have been a little bit of a red flag, maybe. I mean, it's nice that the business was backing their employee, but on the other hand, they may have heard a different story possibly than the one that was brought up in court. So it's definitely a situation that that happens, unfortunately, and probably could be handled a little differently. So that's where the law is there to help us and protect us. And I just saw that Peter joined. Thank you. Okay, so now we are going to talk about another case or another tort, and that is misappropriation of the right to publicity. So that is an attempt by another person to appropriate a living person's name or identity for commercial purposes. So who do you think benefits from this law?
Movie stars.
who are being used.
Movie stars. That's really good. So yeah, movie stars, anybody famous. So their name and their likeness is usually out in public, and someone using that unlawfully, that would be the misappropriation of the right to privacy.
So how do like Elvis Presley like impersonators and like other impersonators, how do they get away with that?
They do have to get there. We'll talk a little more about that in when we talk about trademarks and copyrights and trade secrets and all of that. But they would have to get permission from the family. And for a certain amount of time after his death, they have to have permission. So that's something we'll talk about in chapter, I think it's 7. Yeah, 7. Okay. So we'll talk about that in a little bit. So the invasion of the right to privacy is the unwarranted and undesired publicity of a private fact about a person. That fact doesn't have to be untrue. So they can say it could be true, but if you put it out in public, that's still an invasion of privacy. It's not your secret to share, right? So let's say you're walking through the computer lab at the college and someone is checking their email, their private email, personal email. And you stop and read their emails over their shoulder. Did you do something wrong? Yeah. Does it matter that they're looking at it on a public computer? No. And what if they asked you to read it for them? Then is it wrong?
No.
No. Now they've asked you. They've asked you to actually read it. Now, if you read it to them and then went to someone else and said, this is what this email said, then you're overstepping. Okay. All right. Defamation of character. So false statements made by one person about another. So there's 2 types of this. There's slander, which is oral, and libel, which is written. There are 2 items needed to prove defamation of character, and that's proof of an untrue statement of fact and proof that the statement was intentionally or accidentally published to a third party. So it doesn't even have to be on purpose. If you did it accidentally, that's still defamation of character. So meaning that the third party has seen or heard the defamatory statement. An example is like if I say my taxi driver is a crazy driver, is that defamation of character? It's not. That's an opinion. But if I said my taxi driver was driving so bad that he lost his license and he didn't actually lose his license, I was just saying that just to be rude, then yes, that is defamation of character. I'm hurting his character. I'm hurting his ability to drive the taxi because now there may be an investigation or whatever, right? So there's a couple of business-related torts. There's disparagement, which are false statements about a competitor's product, service, property, or business reputation. And essentially that is the business's version of defamation of character. There are 4 items needed to prove disparagement, and that is proof of untrue statement of fact, statement published to the third party, sounds familiar, right? And knowledge that the statement was untrue and that it was made maliciously. So basically they intend to hurt their competition by making these statements. There's also intentional misrepresentation, also known as fraud, more commonly known as fraud. So it is the intentional defrauding of a person out of money, property, or something else of value. And we're going to talk more about this type of thing later on. There are 4 elements of fraud. There's wrongdoer. There's the wrongdoer made a false representation of a material fact and they had knowledge that it was false. So they did it intentionally to deceive the other party. And then the other party relied on that information and was injured. And basically, there's an example in the book. Let's see, where's the example? So yeah, let's look at that one. So it's the example under intentional misrepresentation under fraud. And it's just the last one in that paragraph. And it says, Matt, a person claiming to be a minerals expert, convinces 100 people to invest $10,000 each with him so that he can purchase on their behalf a gold mine he claims is located in the state of North Dakota. Matt shows the prospective investors photographs of a gold mine to substantiate his story. The investors give Matt their money. There is no gold mine. Instead, Matt runs off with the investors' money. Matt intended to steal the money from the investors. This is an example of fraud. So Matt made a false representation of the fact because there was no gold mine, and he did not intend to invest the money. Matt knew that his statements were false. He knew there was no gold mine, right? And the investors were injured because they lost money because they trusted him with their money. How many of you have heard of this happening? Probably almost all of you, right? There's things out there every single day that's defrauding, that is fraud cases out there every single day. I mean, a lot of times they prey on the elderly. And we get a lot of that with the phone calls and the emails and stuff like that, where you need to give us money right away, those kinds of things. So, so there's also unintentional torts, and that's known as negligence. It states that a person is liable for harm that is foreseeable consequence of their action. So let's look at the ethics case. I love this one. I don't love this one. I love this one. So the ethics case that says, ouch, McDonald's coffee is too hot. And on mine, it's on page 124.
92 in the other book.
Okay, so how many of you guys have been to McDonald's lately and you've gotten a coffee and on the cup it says hot coffee is hot? Have you seen that? This is what prompted them to do that, this case right here. And I'm going to save my voice a little bit, so I'm going to let you guys read through this. I'm going to give you a couple minutes to read through ouch, McDonald's coffee is hot, and then we'll talk about it a little bit.
This case is amusing.
Did everybody get a chance to read it? Do you guys remember hearing about this, or did anybody hear about this? It was huge news, right? What was that?
Yeah, I remembered hearing about it.
Yeah, it was huge news. So now you've heard like the case part of the story, and it's kind of crazy, right? So do you think that McDonald's properly warned Stella Liebeck of the dangers of drinking McDonald's hot coffee? Remember, back then they didn't have that little statement on there that said hot coffee is hot, right?
I mean, I think it's fair to assume all coffee is going to be served hot. So
The fact that they require their franchises to serve the coffee at 180 to 190 degrees Fahrenheit, and third-degree burns occur on skin after 2 to 5 seconds when coffee is served at 185 degrees. And the fact that McDonald's coffee temperature was 20 degrees hotter than any other coffee served by competing restaurant chains. What do you think about that? If you were on the jury for that, would you be like, okay, this is a game changer? Because that's exactly what I thought when I heard about it. I'm like, this lady, is she crazy? Why would she spill her hot coffee on herself? And, and I think the hot coffee is hot thing is kind of like okay, guys, duh, hot coffee is hot, So I felt like that was a little bit of but after reading the case and actually seeing the information, it was extremely hot, right?
So Cindy,
What is
oh, my bad. Go ahead.
what happens to the 2.7 million in punitive damages? Does that money go to her or?
Yes.
Oh, okay.
And
wow.
Jack, you had a question?
Yeah, I had a couple of questions. Did they say in the thing here, did they say that they were like stopped and she opened her cup of coffee, or were they driving and she opened her cup of coffee?
It did say that he was stopped. So it said that her grandson handed her, Chris pulled over so that Stella could put cream and sugar in her coffee. And she put it in her lap, took the lid off, and went to put the cream and sugar in it, and it spilled everywhere. So they weren't moving. The car wasn't moving.
Okay. And then my second question is just kind of silly: was there iced coffee invented back then, or was the thing back then, or?
It wasn't a big thing back then. It was mostly just hot coffee.
Okay.
Iced coffee is it's reasonably safe to say that iced coffee is pretty new. And that's a whole other story. But what do you think about the offer of $800 to Stella?
After
That was
$11,000 in medical bills?
Right. Kind of a little slap, right?
Yeah, they make a grip of cash. That's ridiculous.
So do you think that the punitive damages was justified? So it was 2.7 and then they reduced it to 480,000. So she received $480,000 in punitive damages and 40,000 of compensatory damages. So 40,000 went to her medical costs and, just other whatever. And then the 480,000 was the punitive damages that they required McDonald's to pay. So do you think that was justified?
I think she actually got 160,000 because it said it was reduced by 40,000.
Oh,
Am I reading that right or no?
You're right, actually. Yep.
Okay.
You're right. So yeah, she got 160,000 and 480,000.
I think that's fair because she first offered to settle for $20,000 and they were being like really petty by being really dismissive to her injury, and they could have, I think that she made them a fair settlement, and then they tried to take advantage of her.
Yeah. And they probably thought that they had a good case because it's negligent, right? Because like we said, hot coffee is hot and you should know better than to spill it on your lap, right? what do you, so let's look at it now from the business standpoint. We've been looking at it from Stella's standpoint. So now let's look at it from McDonald's standpoint. So now what happened with McDonald's? McDonald's now has to pay all this money and put a statement on all their cups. So they have to get rid of all the cups that they have everywhere in all their franchises. They have to get new cups, and they have to have a statement on there that hot coffee is hot. So what do you think about that? How do you think that affected them?
They lost
That's a
shitload
lot of
money.
loss.
It's a lot, right? And do you think that they still require the 180 to 190 degrees Fahrenheit for their coffee?
Mm-mm.
No, I think
Probably
that
not.
got changed right away. I don't know that
Mhm.
for a fact, but if it were my business, that would be the first thing to be changed. Is okay, we don't do that anymore. It can't go over 185,000 or 185 degrees, because that's going to burn someone within 2 to 3 seconds, 2 to 5 seconds. So, or let the coffee sit for a minute while they drive through, or whatever it might be, right?
Right.
Okay. So let's look at, or let's talk about negligence. So to prove negligence, the defendant is owed a duty of care, and that duty of care is breached, which causes the plaintiff to suffer an injury, and that negligent act was the actual and proximate cause of the injury. So a duty of care is the obligation that people owe each other not to cause any unreasonable harm or risk of harm. It is decided by applying reasonable person standard by the court. So they will take what they feel is a reasonable person's actions, and if that was, they would apply it to that actual case. So it may also use a reasonable professional standard, because I'm not a medical professional. I'm not a doctor. I didn't go to school for that. So I wouldn't want to be the reasonable person standard for a medical related situation, right? That would be need to be someone that is equivalent to that type of standard. So they have reasonable professional standards if the case has defendants with particular skill or competence. That just means that they'll measure it against a comparable standard. The breach of a duty of care is the failure to act as a responsible person would act, or to exercise care. So if I'm a police officer and I come up on the scene of an accident and I just keep going, could that be a breach of duty of care? Could be, right? Yeah, it could be, because police officers take an oath to protect, right? So they are actually expected to stop at accidents and such, to make sure everybody's okay and make sure everything's okay. The only reason that that might not be is if they were responding to a different accident or something like that, then they may not stop. If they were responding to something else and they're required to respond to that, then they may not stop.
Isn't there something that there's actually been like doctors or something that has been sued for helping somebody because they're not on the clock?
Yep, we're going to talk about that in just a minute. So negligence cannot be proved without proven without an injury. You have to have an injury in the situation for it to be considered negligence. The negligence must also be the actual cause of the injury, and the courts will test this by using the but-for test. So basically that helps to answer the question of if the conduct actually caused the accident to happen. So would it have happened without it? So this happened because of this, or but for this. So would it have happened without it? Yes or no? And that's how they determine. So for negligence, the injury must have been the proximate cause. So this means it had to be foreseeable. And the proximate cause is a limitation on liability that's used in negligence cases. Essentially, if a chain reaction is set off because of the negligent act, it can limit the amount of liability that the defendant would have because of it. So let's see. So let's talk about Let's look at case 5.2. This is Carter versus Indianapolis Power and Light Company and Indiana Bell Telephone Company. And that's on page 126 in my book. So I'm going to let you guys read this one again, and then we'll talk about it a little bit when you guys are done.
I'm sorry, what page was this on? Or what study was it?
So in my book, it's 126. It's case 5.2. It's the negligence case. It's Carter versus Indianapolis Power and Light Company.
It's 94 in mine.
94, thank you. And Indiana Bell Telephone Company, Inc.
Thank you.
So I know you weren't here last week, and I just want you to know that my book is different than everyone else's. So I apologize for that. I can't give page numbers very well, except for, sounds like a couple people might have the same book I do.
Okay, thank you.
You're welcome. All right, did you guys get a chance to read all that? Okay, so the questions, the ethics questions on here is, did the utility companies owe a duty to foresee and therefore move their utility poles to accommodate Mitchell's reckless driving? What do you guys think?
Oh,
No.
No.
That's kind of silly, right? I mean, they're utility poles. They were placed where they're supposed to be placed as according to the city ordinances and all of that. And really, were they at fault? Did they know someone was going to crest that hill at 80 miles an hour? Probably not. So do you think?
Well, and it wasn't even anybody that was involved in the accident.
Right. It was just the utility poles. So it was them and the utility poles, the car and the utility poles, basically. So did Adam's actions contribute to the accident, you think?
Mm-hmm. Yes.
So Adam is the one that was, he was in the front passenger seat. So he wasn't actually driving. But do you think he actually contributed to the accident?
He was the one who was like, let's jump these hills, right? Yeah.
Probably, yeah, probably. And you know, when you get teenagers in a car like that, a lot of times it's the peer pressure thing, right? Oh, let's do it, let's do it, let's do it. And then all of a sudden, this is what's happening and it's spiraling out of control. And unfortunately, in this case, 2 people lost their lives, and that's very sad. But really, Adam's, what did they call it? Representative of the estate of Adam, his representative had really no ground to stand on in this case because the utility poles did nothing. They weren't the cause of the accident, right? Okay. So there's some special types of negligence as well. There's professional malpractice, and we kind of touched on this a little bit ago. This is the liability of a professional who breaches his or her duty of ordinary care. This mostly involves doctors, lawyers, and accountants. Most of the professionals that have malpractice suits brought up against them have special insurance that they're required to hold to help protect them in these cases. It's called E&O insurance sometimes. That's errors and omissions, or it might be there's another name. It's escaping me now, but there is special types of insurance that they buy in these cases. For example, so I know that this professional isn't listed in the doctors, lawyers, and accountants, but I worked for an appraiser's office for quite a few years, and they had a lawsuit come up against them, and it was as a result of, in the place that they were appraising, it was a housing development that was going in. It was brand new housing development that was going in, and there was a freeway that went in shortly after the housing development was completed. And the lawsuit said that they did not disclose that the freeway would be going in next to the houses in their appraisal report.
That is not on the appraiser.
What was that?
That is not on the appraiser.
Exactly. So it's not on the appraiser. It's actually on the builder. The builder or the seller of the property is responsible for letting them know that. And it ended up being a frivolous lawsuit, which means that, you know, they had no ground to stand on. And so the appraiser was fine. But the E&O insurance handled that lawsuit for them. So that was really good. And we actually were able to prove that they did put something in there. They had a site plan in there that showed that there was a potential freeway going in. So it was all just a mess. But I mean, these things happen, and that's why they have to protect themselves from these types of situations. Okay. So negligent infliction of emotional distress, that permits a person to recover for emotional distress caused by the negligent conduct. Negligence per se is a violation of a statute or ordinance that constitutes a breach of the duty of care. And res ispa loquitur, I don't know how to say these things, I'm sorry, loquitur, is the presumption of negligence, and it arises because the defendant was in exclusive control of the situation, and the injury would not have ordinarily occurred but for someone else's, remember, but for someone else's negligence. The burden of proof switches to the defendant in that case. The attractive nuisance doctrine imposes a liability on a landowner to children who have been attracted onto the property and are killed or injured on the property. So for example, when I lived in Las Vegas, we put a pool in the backyard of our house. And when we did, we were required to add a screen to our gate and make sure that our gate the locking mechanism for our gate was up high. And so it couldn't be reached by a child, even though from the street and from in front of our house, you couldn't see our pool. It didn't matter. You still had to have that screen on there so that a child, if like their ball got loose or something and it bounced into our backyard and they went and tried to recover it, they saw the pool and decided they'd take a swim and drown, then it wouldn't be our fault. We were also required to add alarms to the doors on the interior side. So not only are we protecting from the children that are outside of our house, but what about the kids that came over to play with my kids, right? So we had to protect them, and that was required by our insurance company. They wouldn't insure us unless that was done. And that's as a result of that attractive nuisance doctrine. Good Samaritan laws relieve. Okay, so this is what we were talking about. I think it was Vanessa that brought this up, but this is the Good Samaritan law. So this relieves the medical professionals from liability for ordinary negligence when they stop and render aid to victims in emergency situations. This law stems from the issue that medical people have when they were trying to assist people in emergency situations. So let's say that I'm a doctor and I come upon an accident on the side of the road and I stop and I get out and I give aid. Well, in the meantime, I pull someone from a car and I break their arm. They sue me for medical malpractice. So now why did I stop and help, right? So what this is, the Good Samaritan law, that actually covers doctors in those cases so that they are more apt to stop and help and not feel like they should just keep going because, you know, that why should they stop if they're just going to get sued for something anyway?
Wouldn't that also fall under like somebody that holds a CPR card? Because I know when we take a CPR class, they say you have to ask for permission to help somebody first before.
Yes, absolutely. And I have a CPR card too. So thank you for bringing that up. Yeah, we are allowed to stop and give aid, but we do have to ask permission unless they cannot respond. And then we're okay to give them aid. But the Good Samaritan law would fall to CPR, people that have been trained in CPR and do hold a card. If you haven't been trained in CPR and you stop and help someone, you're not covered by that Good Samaritan law. There are some defenses against negligence, such as a superseding or intervening event. So a person, we talked about this a little bit, a person is only liable for the foreseeable events. So the assumption of risk is used when the person knowingly and voluntarily enters into or participates in a risky activity that results in injury. So this is very common, especially in my neck of the woods. I know there's probably not a lot of you that are from Page, but here, and actually we'll talk about it from Flagstaff's standpoint too, but a lot of businesses have to have you sign a document. So how many of you go to Snowball? Go skiing or anything? Some of you, right? So when you do, you have to sign that little waiver when you get your ticket, or your ticket is a, if you buy a pass, usually they have you sign a waiver. And then if you just go buy a ticket, the ticket is on the back of it or something. I don't know, they have it somewhere, but it says, by using this ticket, you agree that you won't sue and this is a dangerous activity and blah, 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 blah. There's a lot of those out here in Page because we have a lot of tour companies and they take kayaks out on the lake. They do, you go through slot canyons. There's all kinds of dangerous things that you can be doing out here. So,
Cindy.
Yep.
So that basically you're basically agreeing that if you get hurt, and we're like it's not like I said, it's not the company or whatever, they're not liable for that injury.
Right. Now so companies have to be very careful when they draft these. They should go and consult a lawyer, because there's a lot of legalese that if they don't say it just right, then they may be liable still. There might be a loophole that they missed or something along those lines. So it's recommended that if you have a business and you are writing up something like this because you have people doing dangerous acts. I love to zip line. I don't know, I hate heights. It's the weirdest thing, but I love to zip line. So when I travel with my family, we zip line a lot, and we sign waivers every single time. And, you know, although I feel pretty safe when I'm up there, there's a lot of things that can happen, right? So that's a good reason to do that. I love going skiing. And again, that's another one. Kayaking, which I don't go with tour companies much unless we're on vacation, and then maybe we'll go with a tour company. But all those kinds of things, you have to sign a waiver if the company is smart. But if you read, most people don't even read the waivers, but if you read the waivers, you might find that they don't cover a specific event, or you might be able to, if you were injured or something as a customer, then you may be able to find something in there that you can twist to where, oh, well, you are still negligent. And a lot of people will do that.
What about like fairs or carnivals and those kinds of things? Because you don't really sign anything when you enter, but is it on the ticket?
It is. A lot of times it's on the ticket, and it says you release liability by using the ticket. Cruise ships, they have something like that too. And we'll talk about that a little more later on, but because there is some stuff about cruise ships later on that we'll talk about. But if you go on a cruise, I love cruising. I don't know about you guys, but if you go on a cruise, all that stuff that you do before you actually go on the cruise, it says on there that by presenting the ticket to the cruise ship, you are assuming liability. So there's a lot of, what was that?
I'm in class.
Okay, so case.
Oh, I only asked because I sign a waiver when I go to like a motocross track, and I've read it a couple times, and I wasn't.
That's a perfect example at the motocross track because there's a lot of room for risk there, for sure. I'm going to skip this one, but if you guys want to take a look at case 5.5, Lilia versus the Greater Gulf State Fair. I want to move on because I feel like I'm getting behind a little bit, and I want to make sure that we get through all these chapters. So that one's a good case. So if you want to take a look at that at some point and just kind of think about it.
Hey, Cindy.
So, yes.
I know we're trying to get ahead and stuff, but just to kind of, just to simplify things, basically, hypothetically, let's say Snowball says, if you bruise yourself, we're not liable for it. But if you, let's say they don't write something about breaking your arm, you break your arm, can you do something about that, and start suing and stuff? Is that kind of?
Yeah, and for the most part, places like the Snowball, they're going to use a lawyer and they're going to make sure that that's airtight. But there's always ways around. People will always try to get around it. Now, will they succeed or not? That's up to the judge and jury. But in this situation where you're signing those waivers, it doesn't hurt to take a look at them. A lot of times they don't give you the waiver either. You sign it and you're done. That's just for them to keep on file. If anything ever happened, then they've got something. And I know one of the waivers that I signed, I was scanning through it because I don't read them either. I'm usually on vacation and I'm like, oh, whatever, I just got to do this so that I can go on it, right? So, but one of the waivers that I signed, I was scanning through and it said that basically that I couldn't sue if anything happened to me. And if upon my death, my family could not sue. So they actually covered beyond me. So if something happened and I died, then my family couldn't come back and say, hey, you owe us because she did the zip line and fell to her death, so you really have to kind of keep an eye on that stuff.
I have a question about what if it's like negligence, like they just hadn't had safety harnesses rechecked in so many years or something like that.
And that's definitely something that people would try to do. They would have an investigation. So obviously if something happened at most of these places and I was ziplining or whatever and the rope break, it's not a rope, the chain broke. I'm going to call it a chain. It's not a chain either. The cable broke. If it broke and I plummeted to my death or even got injured by it or whatever, there would be an investigation. And in most cases, and the investigation would turn over if the company had been negligent. Maybe they forgot to do some sort of maintenance because they have safety protocols that they have to go through. And if they forgot to do them or they didn't sign off on them or something, then there may be something that could be done about that in the future. So let's move on. Let's talk about partial liability situations. So contributory negligence holds that a plaintiff is partially at fault for the injury. Then they cannot recover against the negligent defendant. So comparative negligence assesses that the damage and apportions them according to fault. So if you're at 75% fault, then you would pay that amount of the damages. So basically, if you contributed to the damages, then you wouldn't be able to recover for those, right? So let's say, suppose a driver who is driving over the speed limit negligently hits and injures a pedestrian who is jaywalking against a red "Don't Walk" sign. So this is kind of like what we were just talking about, right? So maybe they forgot to do maintenance on their zip line and that's why I fell, right? So in that case, it would be their negligence that hurt me, and so maybe that would reverse it. But suppose the jury finds that the driver is 80% responsible for the accident and the jaywalker is 20% responsible. The pedestrian suffered 100,000 in injuries. So under the doctrine of contributory negligence, the pedestrian cannot recover any damages from the driver. So under the comparative negligence, when the comparative negligence rule is applied, and the pedestrian suffered 100,000 of injuries, then the result is much more fair, because in this case, the plaintiff pedestrian who was 20% at fault for causing his own injuries can recover 80% of the damages, or 80,000, from the negligent defendant. So let's talk about strict liability really quick. So strict liability is liability without fault. This is something that comes up when you're not negligent, but you're still liable for the damages. Very popular situation. These is the most common, and actually I think the example in the book is also this way, but is pets. Pets, you are liable for the action of your pets, even if you're not around when the injury takes place. So in this case, the book gives the example where the dog bites a child after the child hit the dog. And even though the child is the one who hit the dog, the owner would still be liable for that injury the child sustained.
What if they were like someone was breaking into your property and your dog attacked them?
So that's a funny one, because it actually has been brought up. So you could get them for breaking and entering, and in most cases that would nullify, make them, because now that's the comparative thing, right? They were the ones that broke in. They're at fault as well. But there have been lawsuits that have been brought by those kinds of situations. I'll have to see if I can find one, and I'll have to bring it in next time.
Would having signage help with that? Like having like a beware of dog sign, like help cover you?
Yes, absolutely it will. We have one on ours, even though my dogs would probably lick you to death before they would bite you or anything, but we do have one on our gate that says beware of dogs. So yeah, that's definitely a good way to do it. And the reason that we do is, I've told you guys I have an Airbnb, and so I don't want my guests to just walk in my backyard. So we put the beware of dog on there so that they don't just walk into our backyard and have our dogs, get crazy with them or something. Who knows? You never know with dogs. They can be a little bit unpredictable at times. Okay, so let's move on to chapter 6. This is criminal law and cyber crimes. A crime is a violation of a statute for which the government imposes a punishment. A collection of criminal statutes is known as a penal code, and statutes that provide for criminal violations and penalties is known as regulatory statutes. In a criminal lawsuit, the government is the plaintiff and is represented by a lawyer called a prosecutor. The accused is the defendant and is represented by a defense attorney or public defender. Crimes are classified from serious to minor. The most serious type of crime is a felony. These crimes are considered inherently evil. A misdemeanor is a crime that's prohibited by society, and these crimes are less serious than a felony. Violations are the least serious of crimes. You may have had a violation in the form of a traffic violation. If you had one, most likely you had to pay a fine. There are two types of crimes. There's intent crimes and non-intent crimes. Most crimes require intent, and the elements that must be proven of an intent crime is the guilty act and the evil intent. And that's, so there's some Latin words for that. The guilty act is actus reus, and the evil intent means mens rea. And I don't know if I butchered that. I'm so sorry. I'm not very good with Latin. Criminal intent may be broken down into two elements. Specific intent, which require that a specific result is intended from the illegal act. So for example, premeditated murder. And general intent, which would require that it is known that the actions would lead to harmful results. So for example, assault and battery. Non-intent crime is a crime that imposes criminal liability without finding intent. You'll often hear of reckless or gross negligent conduct that causes injury to another person as an example of non-intent crimes. Let's look at, so on, I'm not sure what page for you guys, 141 for me, it's criminal acts as the basis for tort actions. This says an injured victim of a crime or the relatives of a deceased victim of a crime may bring a civil action against a wrongdoer who has caused the injury or death during the commission of a criminal act. Civil lawsuits are, thank you so much for that page number, everybody, 109. Civil lawsuits are separate from the government's criminal action against the wrongdoer. In a civil lawsuit, the plaintiff usually wants to recover monetary damages from the wrongdoer. So for example, a person commits the crime of battery and physically injures the victim. In this case, the government can prosecute the perpetrator for the crime of battery. In addition, the victim may sue the perpetrator in a civil lawsuit to recover monetary damages for the injuries the victim suffers because of the attack. In many cases, a person injured by a criminal act will not sue the criminal to recover civil damages because the criminal is often judgment proof. That is, that the criminal does not have the money to pay the civil judgment. Criminal and civil law differ in the following ways. So there's a little table here, and it says the issue is the party who brings the action is, and in civil law, it's the plaintiff, and in criminal law, it's the government. So this little table is really good because it kind of gives you an idea of the differences between the civil law and the criminal law. So the issue being trial by jury, in civil law, yes, except for actions for equity. And in criminal law, it's yes. Burden of proof, in civil law, it's preponderance of the evidence. And in criminal law, it's beyond a reasonable doubt. Jury vote, in civil law is judgment for plaintiff, requires specific jury vote, which is, for example, 9 of the 12 jurors. And in criminal law, conviction requires unanimous jury. Sanctions and penalties, monetary damages, and equitable remedies. For example, injunction, specific performance, and that's under civil law. And under criminal law, it's imprisonment, capital punishment, fine, probation. Okay. So in order for an arrest to be made, probable cause must be present. And in most cases, an arrest warrant must be obtained. Probable cause is the substantial likelihood that a person either committed the crime or is about to commit the crime. An arrest warrant is a document for a person's detainment based on showing of probable cause. Once the person is arrested, they're taken to the police station to be booked, which is the administrative procedure for recording an arrest. The next step is indictment or information. An indictment is the charge of having committed a crime based on the judgment of a grand jury. Information is the charge of having committed a crime based on the judgment of a judge. Then an arraignment proceeding is held where the accused is informed of the charges against them and they enter a plea of guilty or not guilty charges. An arraignment may be negotiated where the accused admits to a lesser crime and the government imposes a lesser sentence called a plea bargain. So plea bargains are desirable because they save costs, avoid the risk of trial, and prevent overcrowding. If the case goes to trial, all the jurors must agree unanimously in order to find the accused guilty. If the jurors do not agree, the jury is considered a hung jury. So common crimes include murder, which is the unlawful killing of another person without justification. Case 6.1, State of Ohio versus Wilson. I'm not going to read this one either. I'm going to skip it. If we have time at the end, I'll come back to it. But if you guys want to take a look at that at some point, that'd be great. Robbery is the taking of personal property from another person by use of force or fear. Burglary is the taking of personal property from another's home, office, or commercial or other type of building. Larceny is the taking of another person's property other than from his or her person or building. And theft is the general crime of taking personal property from another person. Receiving stolen property is a crime that involves knowingly receiving stolen property and intending to deprive the rightful owner of that property. And arson is the willful or malicious burning of a building. So there are some business and white collar crimes, and those are, so when a crime is committed by a business person, they're often referred to as white collar crimes. So those crimes are like forgery, which is the fraudulent making or alteration of written document that alters the legal liability of another person. So signing another person's signature without intent to defraud is not forgery. For example, my mom always signed my dad's checks, always. She always did. She did the banking, she did the grocery shopping, she did all of that. And back then we used checks, not so much anymore, a little bit, but not so much anymore. And she would always sign his name. In fact, we always used to joke that no one would ever know what my dad's signature looked like because he never signed it. My mom always signed it. So in that case, that was not forgery because my mom had my dad's permission to sign his name. Embezzlement is the fraudulent conversion of property by a person to whom that property was entrusted. So for example, there's a Wells Fargo case where the executives set unrealistic goals for their employees. I don't know if you guys remember this. This wasn't too long ago, probably like 4 or 5 years ago. Wells Fargo was in this major situation because they set these unrealistic goals for their employees, and they created millions, the employees created millions of savings accounts and checking accounts for customers without their consent. And they were doing it so that they can meet those goals that were set for them. They moved money out of existing accounts and into the new ones. And these accounts were made it so that the customers were seeing more fees and the problems were escalated to the regulatory agencies. That is embezzlement. Bribery is a crime where one person gives another person something of value for a favor in return. So a payoff or a kickback. Extortion is a threat to expose something about a person unless that person gives something of value, also known as blackmail. Criminal fraud is a crime that involves obtaining title to property through deception or trickery. Mail fraud or wire fraud is mail or television, radio, computer, etc. is used to defraud another person. Money laundering is when money from an illegal activity is run through a legitimate business to make it look like it was earned legitimately. The Money Laundering Control Act was enacted to make it a crime. So have you ever been to a bank and tried to take out more than $10,000 or even deposit more than $10,000. Okay, so if you ever do, or if you ever have, you know that the bank is going to require you to fill out forms, and they're going to report it to the IRS.
They have to report it, yeah.
They do, yes. So anything over $10,000, if it's in or out, $10,000 is the number. And that's as a result of this money laundering stuff.
Is there a time frame that you can do like 999,000 or $999, and then do you have to wait a X amount of time before you make another deposit?
So I
Before
believe it's on a daily basis, but I'm not sure. You would have to check with your bank, and I'm not sure if banks do it differently, or if it's at that time. I don't know. I've done it once, and it was only one time, and I went in and took out $10,000, and that it was crazy. It was over. It was like 10 or 13,000 or something like that. But I was buying a vehicle, and I had to take out that much cash to go get it. And so I went in and took that much money out, and I had to fill out a bunch of forms, and they had to verify that it was okay. They had to call their supervisor. Filed the forms with the IRS and the whole thing. So it was a big, crazy mess. But you know, if you're not doing anything wrong, it's fine. If you're doing something wrong, it's not fine. So there you go. All right. Criminal conspiracy is a crime in which two or more people enter into an agreement to commit a crime, and an overt act is taken to further the crime. So it's not just criminal conspiracy. You can sit there and talk about a crime all day long and say, oh, you know, I think I'll go down here and rob this bank. What do you think? You guys want to come with me? Let's go. But until we actually take the steps to go do it, it's not criminal conspiracy. Cybercrime is a crime that's committed using computers, email, the internet, and other electronic means. To combat against these crimes, there have been some acts enacted. For example, the Information Infrastructure Protection Act, or the IIP Act. And that makes it a crime for anyone to intentionally access and acquire information from a protected computer without authorization. This kind of crime happens all the time. I don't know if you guys have ever gotten those emails from a company that you've dealt with in the past. It's happened to so many different people and places, and but they'll say, "Oh, your information may have been compromised." There was a big thing. Target just had a big thing a few years ago where their systems were compromised, and a bunch of information was taken from Target. Recently. What's the recent one that I've just seen not too long? Oh, Experian, the credit reporting agency, had an issue. I think it was Experian. No, Equifax. One of them. Anyway, one of the credit agencies actually had an issue. There's been quite a few in the recent years, so it's definitely something that's out there. Okay. Right. So, and you're talking a little bit, and this is kind of going along the lines of criminal conspiracy too. So the act of, so an overt act is taken to further the crime. So let's say that they go out, they say, hey, I'm going to torch the city hall or whatever. And that alone wouldn't necessarily be, it might be investigated. It wouldn't necessarily be a crime if they just said it. Our tensions are high right now. So it could be escalated just from that type of situation, because there is a lot of unrest going on right now. But let's say that I said that, and then I had a gas can or something along those lines in my house, or I went and purchased fuel, or I went and purchased something that could actually that could actually go toward doing what I just said I was going to do. I'm sorry, I got distracted because is anyone else having internet issues?
Yeah, it's the time.
It's off and on?
It's around this time. It's around this time every day.
It might have to do with the snow too.
You know, I agree with that. I think computers react to weather. They really do. Internet reacts to weather. I mean, you think about it, and it would definitely be
interference.
So yeah, I know. What's up with that? We need to be turning on our Netflix right now. No, I'm just kidding. So,
Right.
all right, this is what we're gonna do to try to. And my internet and page is not. It's a little iffy too sometimes. So, what we'll do to try and get it so that the internet isn't so bad, and hopefully everybody is able to get back on that was kicked off. Let's go ahead and everybody stop their videos. We'll still be here. We'll still be talking. But we're going to stop the videos because that can help the internet because it's not streaming picture too. It's only streaming sound. Thank you. Let me just respond here.
Do you think with Cherie's comment about them coming in arrest, because it was written in print as opposed to just being verbally mentioned, that it holds more true?
That is possible. And it also depends on where that conversation went. Maybe it wasn't just that comment. Maybe there were other plans made. So let's say they said, oh, I'm going to do it at this time of day on this day, and it's blah, 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 blah. And I'm going to do it with this type of fuel. I'm going to do it with, or accelerant or whatever. I'm going to use cocktail bombs, whatever it is that they're saying. So if they were to put more detail in there and they start that's actually an overt act that's furthering the crime. I'm planning it now. I'm actually going in and starting to take steps to actually do it.
Okay. I have a question.
Okay.
What would be some protection, like uses if you were a business owner but you didn't own the land and you're renting it, and someone was trying to sell out from under you, but the building's like old, and could you make it like a historical like monument? Is that?
That's a very specific case. And what you would want to do is you would want to talk to a lawyer that actually that specializes in real estate to get that information. That would definitely be something I would do as a business. Is I would contact a lawyer that specializes in real estate and say, hey, what can we do and how can we make this work so that so that this building isn't sold out from underneath me, or the land's not sold out from underneath me. So I would definitely check with them. That's very specific, and there's a lot of situations that are a lot of issues that can go into that. So I wouldn't want to tell you something and not be right. And plus, like I said, I'm not a lawyer, so I don't feel like I should be giving that kind of advice.
Hey, Cindy.
Yes.
So kind of going back a little bit, back to forgery and stuff like that. So let's say that you and your spouse are like sharing an account, and you need to sign up for something, like, and you like, let's say that you sign up something for your husband. Would that be kind of forgery, even though you guys are sharing an account? Or
if my husband gave me the okay to do it, then it's not forgery. So if let's say my husband, and this is a case that's actually happened. My husband travels or he used to, he doesn't so much anymore, but he used to travel for work and he would be gone a lot. And let's say that we have a contract that has to be signed and it has to be signed before he gets back. And then we'll say that it's before the digital age, which it was before we were able to do a lot of this online. You had to do a paper copy. There have been cases where I have called him and said, hey, I need to sign this. It needs to be taken care of today. You know, is that okay? And he'll say yes, and I'll go ahead and sign it. If he didn't give me permission to do that, then yes, it could be construed as forgery.
Okay, cool. Thank you.
You're welcome. Okay, so we're going to move on. So we talked about the IIP Act. So there's also the Identity Theft and Assumption Deterrence Act. And this makes it a crime to knowingly transfer or use without authority the identity of another person with the intent to commit an unlawful activity. So someone steals their social security number or their whatever, and they open up credit cards or whatever against them. That would be that would fall under the Identity Theft and Assumption Deterrence Act. Counterfeit Access Device and Computer Fraud Abuse Act, the CFAA, makes it a crime to access a computer to knowingly obtain restricted federal government information, financial records of financial institutions, or consumer reports of consumer reporting agencies. So if someone were to, for example, access a bank, that would be financial records of financial institutions, right? So if they were to go to a computer and to knowingly obtain that information, then they would be under the CFAA. There's a case, 6.2. It's a pretty good one as well. If you get a chance to read that one, I'm going to skip it for now. In my book, it's on page 152. And but if you get a chance to read that one, that's a good one too.
120.
Thank you. The U.S. Constitution has safeguards in place to protect individuals and businesses. The Fourth Amendment, for example, provides protection for people to be freed of unreasonable search and seizure by the government. In most cases, they would have to obtain a search warrant from a judge showing probable cause before they can search a designated place for certain articles, items, or documents. If a search is conducted and it's deemed unreasonable, the exclusionary rule would prohibit any information brought to light by the search as excluded unless it falls under the good faith exception. Case 3, 6.3, I'm sorry, Maryland versus King on page 153 in my book. That one is also a good one to look at. And let's see. The Fifth Amendment includes a provision that a person may not be required to be a witness against themselves in a criminal case. This is known as privilege against self-incrimination. There are a lot of people out there that have not read the Constitution and don't know their rights. And as a result, the Supreme Court requires that criminal suspects are read their Miranda rights before they are interrogated by the police officer or any government official. Have you ever heard of attorney-client privilege? So that is the protection that a client is afforded from their attorney being called to testify against them. So that way you don't feel like you can't tell your attorney anything about the case to help your case. Because if the attorney was called, then that would be, difficult for you to actually open up to them. So they have attorney-client privilege, and generally you have to retain that attorney before the attorney-client privilege is in effect. And by retain, I mean that you would pay a fee, and it could be just $1. But whatever it is, it's the retaining fee for that lawyer. Immunity from prosecution is the government's agreement not to use against a person granted immunity any evidence given by that person. The double jeopardy clause protects a person from being tried twice for the same crime. The Sixth Amendment has the right to a public jury trial protection. And the 8th Amendment prohibits the torture of criminals, so it protects them from cruel and unusual punishment. So it does not include death by lethal injection, as that was deemed not cruel and unusual punishment. There's still a lot of people that feel that it is cruel and unusual punishment, though. So let's move on to chapter 7. So chapter 7 is intellectual property and cyber piracy. How many of you have heard what a trade or know what a trade secret is?
Isn't that like a recipe for like Kentucky Fried Chicken or something?
That's the first thing I think of too, right? I mean, it's just a, that's what I go to. I go to like the special sauce or anything at a food establishment. And it's not just food establishments, but many businesses have trade secrets. It could be, your trade secret could be a code, right? That you wrote for an app that you developed or something. That could be your trade secret. Have you ever worked for a company that has a trade secret? Anybody? No? Okay, so like I said, I think of this, the special sauce, the secret sauce. Cane's comes to mind. Raising Cane's. I really like that place. And my daughter used to work there. And they don't give out the recipe for that sauce, just so you know. She didn't even know what was in it. So a trade secret is a product, formula, pattern, design, compilation of data, customer lists, or other business secret. Trade secrets are intellectual property of the business, and other items that are intellectual property of a business would be like patents, copyrights, and trademarks. There are federal and state laws that protect intellectual property rights from misappropriation and infringement. Competing companies may try to reverse engineer to find out what the secret recipe is. It is lawful to do that. So you can reverse engineer and discover a trade secret. So maybe I try to figure out what's in that secret sauce and I just experiment until I get it. Like I start pulling it apart and I use like a person that knows how to taste things and whatever. Anyway, so however, if I did that and I was a competitor and I used the trademark name of cane sauce or whatever it would be, then that would be unlawful. In business, the tort of misappropriating a trade secret allows the owner of the trade secret to bring a civil lawsuit where they can recover profits for the competitor made while using the trade secret, and recover for damages and obtain an infringement so that the competitor is not allowed to divulge or use the trade secrets anymore. So for me, it's on page 165. It's the ethics case. Coca-Cola employee tries to sell trade secrets to Pepsi-Cola. So we're going to read through this really quick. 133, thank you. So PepsiCo received a letter sent to the company by an employee of Coca-Cola Company that offered to sell PepsiCo trade secrets of Coca-Cola. The letter stated, "What if you knew the markets Coca-Cola was going to move into and out of and beat them to the punch?" The letter proposed selling trade secrets regarding a proposed Coke product codenamed Project Lancelot for $1.5 million. PepsiCo notified Coca-Cola officials and the federal authorities. The Federal Bureau of Investigation, or the FBI, initiated an investigation into the matter. The federal government brought criminal charges against Coca-Cola Secretary Joya Williams, and during the trial, prosecutors produced the letter as well as a videotape of Williams putting the confidential documents and samples of Coke products that were still in development into her bag. Williams was convicted by a federal jury of conspiring to steal Coca-Cola trade secrets and attempting to sell them to arch rival PepsiCo. The trial court judge sentenced Williams to 8 years in jail. The U.S. Court of Appeals upheld the decision, and 2 other co-conspirators were arrested and pled guilty. So do you think that Williams acted loyally to her business in this case, to Coca-Cola?
No.
No, absolutely not, right? Did PepsiCo do what it was supposed to do?
Yep.
Yeah, they acted really ethically, right? They said, hey, this is crazy. We're going to take it to Coke and let them know that they've got a problem. And they also escalated it to the FBI. So how likely is it that PepsiCo would have paid Williams and her co-conspirators the money they demanded?
Not likely.
In this case, no, because PepsiCo went to Coca-Cola and said, this is what we're going to do. But there are cases out there where this is something that PepsiCo could have said, okay, 1.5 million, drop in the bucket for some research that we need, right? So we're just going to give that to them, and then we're going to take all this research. There is risk to doing that, obviously, and obviously that's not the ethical way or the legal way to do it. And there's a lot of risk because what might happen is, let's say that person was trying to set them up or something like that, and then they end up getting in trouble for paying for trade secrets and doing stuff with them.
So, do you know of a company that has tried to do something like this and has gotten caught, with trading secrets?
Off the top of my head, no, but I'll bet if we looked it up, we could find some. It has happened. I mean, otherwise this wouldn't be such a big deal, right? So I'm trying to think of one that I've heard of. But this is definitely something that is detrimental to businesses, and they try to protect against it. So in cases like this, Coca-Cola might, going forward, have their employees sign a confidentiality agreement that would also help them toward that. First of all, it makes sure that they understand they're not supposed to do this, which they should anyway, but it makes sure that they understand that. And they also might, it would also serve as a way for Coca-Cola to bring charges against that person because they did what they did. Let's talk about patents real quick. So a patent allows an inventor the exclusive right to use, sell, or license the invention for a limited amount of time. To get a patent, you would have to fill out a patent application and file it with the U.S. Patent and Trademark Office, or the PTO. There are no state statutes for patents, so they are all handled at a federal level. Once the patent is approved, it's issued a patent number. So I'm sure that you guys have probably heard people say patent pending, or you've seen that on something, an item that you've bought or something, and it says patent pending. So what that means is it just means that they've submitted their application for a patent, but they're still waiting for the approval. There are certain requirements that need to be met for obtaining a patent. So it must be novel, which means it's new and has not been invented or used in the past. It must be useful, so it has to have a practical purpose, and it must be non-obvious. A patent provides protection for only a limited time, 20 years for utility patents and 14 for design patents. The term begins when the application is filed. So that's a little different than most things. Usually it's when it's approved, but in this case, it's when it's filed. And that's why you see that patent pending, because they're already in that timeline. So they want to get their stuff out there, even though it's still just pending. If someone uses another person's patent without permission, they are committing patent infringement. And in lawsuits, the patent holder can recover monetary damages, other damages, an order requiring the infringer to destroy their article, and an injunction preventing them from doing it again. So copyright. I'm pretty sure you guys all know or have heard of a copyright. In fact, if you look in your book at the title page, just past the title page in the book, there's a page with a bunch of information on it. And in my book, it's about halfway down, but somewhere on that page, you're going to see a little C with a circle around it. And then it's going to have the publisher and the date or the year of publication. That is the copyright for our textbook. So a copyright gives the author the exclusive right to publish, sell, license, and distribute the work. Only tangible writings can be copyrighted. Writings is used as a broad definition for all writings, which include paintings, drawings, greeting cards, cartoons, sound recordings, and a bunch more. To obtain a copyright, you must register your work with the U.S. Copyright Office. A copyright registration certificate will then be issued to the copyright holder. The copyright is good for the life of the author plus 70 years for the individual, and the shorter of either 95 years from the year of first publication or 120 years from the year of creation for the business. So copyright carries similar penalties to that of the patent infringement. The copyright holder can recover any profit made, damages suffered, or an order requiring destruction and an injunction preventing them from doing it again. So when, I think it was Vanessa that brought up Elvis, was that right? Vanessa, was it you? So, yeah, okay, so Elvis impersonators. So Elvis impersonators, in this case, Elvis was not necessarily trademarked, as his style and everything was trademarked. So as far as impersonating him in that regard, it may not be unlawful, but his songs, using his songs would be. And it would be for the life of the author plus 70 years for individuals, or the shorter, so that would be for him. So the life of the author plus 70 years. So in order to not copyright, do I need to stop my lecture? Am I committing copyright infringement right now? The fair use, I'm sorry, go ahead.
There's like exceptions for like educational purposes and stuff, right?
Yes, absolutely. So the fair use doctrine allows certain protections against copyright infringement. So as a teacher giving a lecture on this book, I'm provided certain allowances, and as a student you are too. You can quote information from the book as long as you're properly citing the source and author. And I can talk about this book because we know we're talking about this book, right? I've already told you guys, this is the book we're talking about. So you know. So we're not actually committing copyright infringement right now. So what is your first thought when I say trademark? Is it Nike or McDonald's? You know, the golden arches or the little swoosh for Nike, those types of things are service mark. So a mark is any trade name, symbol, word, logo, design, or device used to identify and distinguish goods of a manufacturer or seller of services of a provider from those of other manufacturers, sellers, or providers. So there's several types of marks. There's the trademark, which is the distinctive mark, symbol, name, word, motto, or device that identifies the goods of a particular business. So that could be the golden arches, right, for McDonald's. A service mark is a mark used to distinguish the services of the holder from those of its competitors. So, you know, Nike doesn't necessarily put Nike on all its sneakers, but you know, the little swoosh thing, you know that you're looking at a Nike one, and that's so that you could distinguish that it's a Nike and not Reebok, right? A certificate mark is a mark that establishes certain geographical location requirements, quality standards, material standards, or mode of manufacturing standards that must be met by a seller of products and services in order to use the certification mark. The collective membership mark is a mark owned by an organization whose members use it to identify themselves with a level of quality or accuracy or other characteristics set by an organization. And an example of this would be CPA, or Certified Public Accountant. That would be a mark that would tell you that I hold myself, if I were a CPA, I hold myself to a professional standard, right? To register a mark, you would need to file an application with the US Patent and Trademark Office. The mark would have to either be distinctive, which is unique, or have a secondary meaning. Trademark infringement is similar to patents and copyrights. Okay. So we've talked about internet, and we've talked about how the internet has opened things up like crazy for crime, computer crime, right? Cyber piracy is defined as various deceptive practices that companies or individuals engage in to profit from online users. The internet has opened up new ways to infringe on intellectual property. Several acts have been established that expand penalties to include cyber infringement of intellectual property rights. For example, the EEA, or the Economic Espionage Act, the No Electronic Theft Act, or the NET Act, and the Digital Millennium Copyright Act, or the DMCA, are some of the acts that have penalties for cyber infringement. So we're going to look at, maybe, let me see here. In my book, it's on page 173. It's the Critical Legal Thinking Case, Cyber Piracy, BMG Music versus Gonzalez.
Can you say that one more time?
I'm sorry, what was that?
Can you say that one more time?
So it's, in my book, it's page 173, but it's the BMG Music.
146 on ours.
146, thank you. So Cecilia Gonzalez downloaded 1,370 copyright songs on her computer using a file sharing network during a few weeks. And she kept them on her computer until she was caught. BMG Music sued Gonzalez for copyright infringement of 30 of these songs. Gonzalez defended, arguing that her downloading of these copyrighted songs was lawful. Gonzalez's position was that she was just sampling music to determine what she liked, enough to buy at retail. She also defended by arguing that other persons were greater offenders than she was. The US District Court found Gonzalez liable for copyright infringement. The court granted summary judgment in favor of BMG Music, assessed $22,500 in damages against Gonzalez, and issued an injunction against Gonzalez, enjoining her from further copyright infringement. The US Court of Appeals affirmed the district court's decision. The Court of Appeals stated, a copy downloaded, played, and retained on one's hard drive for future use is a direct substitute for purchased copy. As file sharing has increased, the sales of recorded music have dropped. The events likely are related. Music downloaded for free from the internet is a close substitute for purchased music. Many people are bound to keep the downloaded files without buying originals. That is exactly what Gonzalez did. Nor can she defend by observing that other persons were greater offenders. Gonzalez's theme was that she obtained only 30 or 1,300 copyrighted songs, is no more relevant than a thief's contention that he shoplifted only 30 compact discs, planning to listen to them at home and pay later for any he liked. BMG versus, or I'm sorry, do you think that Gonzalez knew that she was violating the law?
Yes.
Yes. most likely. I mean, there are situations where she may have been oblivious to that, but in most cases, that's something that's very prominent anymore, to where people know that that's not right. Should Gonzalez have been exonerated because others were greater offenders?
Wow.
No. Have you ever unlawfully, never mind, let's not answer that. I don't want to know. Okay. I'm not going to ask that question. Okay, so let's go ahead and take a look at chapter 8, because this is the one we need to get into for sure. All right. Chapter 8 talks about ethics and social responsibility of business. Ethics are a set of moral principles or values that govern the conduct of an individual or group. Practicing good ethics basically means doing the right thing. Following the law also means doing the right thing. So ethics and law are intertwined. However, there are times when they don't necessarily overlap. For example, the law may require something that a person may view as ethically wrong, and vice versa. As I mentioned previously about a class action lawsuit that I was almost involved in. I don't know if you guys remember that. In that situation, there was nothing in the law that said that the medical practice couldn't reuse tools to save costs. So in the case that I was in, they were reusing certain medical tools to from one patient to another. And the law doesn't necessarily say that a medical practice can't do that. However, most people would view that as wrong. And the part where the doctor broke the law is that he put people's lives at risk by trying to save on those costs. He's a doctor.
Like I couldn't find it for the longest time.
He's a doctor and he's supposed to
And I
protect
asked someone,
people.
like, oh, it's in the dairy section. I was like,
He committed
it's the dairy section.
Milk.
And I was right next to it. But they had my
sorry about that. He committed medical malpractice and can never again practice medicine as a result. Let's look at case 8.1. I have this on page 188. It's Walmart Stores Inc. versus Samara Brothers Inc.
Ours is 156.
156. Thank you. Okay, so Samara Brothers Inc. is a designer and manufacturer of children's clothing. Samara sold its clothing to retailers, which in turn sold the clothes to consumers. Walmart Stores Inc. Operates a large chain of budget warehouse stores that sell thousands of items at very low prices. Walmart contacted one of its suppliers in the Philippines, or Judy Philippine Inc., JPI, about the possibility of making a line of children's clothes just like Samara's successful line. Walmart sent photographs of Samara's children clothing to JPI with the name Samara readily discernible on the labels of the garments, and directed JPI to produce children's clothes exactly like those in the photographs. JPI produced a line of children's clothing for Walmart that copied the designs, colors, and patterns of Samara's clothing. Walmart then sold this line of children's clothing in its stores. Samara discovered that Walmart was selling the knockoff clothes at a price that was lower than Samara's retailers were paying Samara for its clothes. After sending successful cease and desist letters to Walmart, Samara sued Walmart, alleging that Walmart stole Samara's trade dress in violation of Section 43A of the late Lanham Act. The U.S. District Court held in favor of Samara and awarded damages. The U.S. Court of Appeals affirmed the award to Samara, and then Walmart appealed to the U.S. Supreme Court. And the issue in this case is, must a product's design have acquired a secondary meaning before it's protected as trade dress? So the US Supreme Court came back and said the Lanham Act in Section 43A requires the producer to show that the allegedly infringing feature is likely to cause confusion with the product for which the protection is sought. In an action for infringement of unregistered trade dress, a product's design is protectable only upon a showing of secondary meaning. So the Supreme Court reversed the decision of the US Court of Appeals and remanded the case for further proceedings consistent with its opinion. So do you think Walmart acted illegally in this case?
Yes.
It was definitely unethically, right? Because they shouldn't have been
Yes.
doing that. They were ripping off someone else's design.
But because she didn't have a patent, right?
But she didn't have it trademarked because it doesn't have, or yeah, a patent or whatever, a trademark, whatever mark she was wanting. But she didn't have that because it doesn't have a secondary meaning. It's clothing, and it doesn't necessarily mean any more than just clothing, right? So if her design was something that was exceptional, what were the allowances were that they were unique? I'm trying to find it. Unique and have a secondary meaning. So it would have to be distinctive or unique and have a secondary meaning. So if no one else made a piece of clothing that was in that exact same design, then maybe she would have a case, but it also has to have that secondary meaning. So in this case, they said, no, it doesn't.
So what would fall under that law for a secondary meaning?
So clothing would be difficult because clothing is clothing, right? So let's see what they have. Do they have an example in here?
When you're saying secondary meaning, I don't know if I understand what you mean by that. Does that mean like if it had like words on it or a certain picture, or I don't think I understand what that means.
So that's what I was just looking for. I was looking for a good example to give you guys because my brain's done. But let's see. So let's say, for example, okay, so here's an example in the book, from the book. So the example in the book, so ordinary, okay, so first of all, secondary meaning means ordinary words or symbols that have been taken on a secondary meaning can qualify as marks. These are words or symbols that have established meaning but have acquired a secondary meaning that is attached to the product or service. So for example, Nike's Just Do It. Those words now have a secondary meaning, and that's what Nike made of it. Or I'm loving it from McDonald's, that's another one. Or Windows from the Microsoft Corporation, Windows took on a whole new meaning, right? Or Ben and Jerry's ice cream, those are just words, but when you put them all together, you know exactly what they mean. They mean you're getting some ice cream, right?
Okay, that makes sense, right?
Does that make more sense?
Yeah.
All right, good. I'm ready for ice cream. Let's have some.
So it's like they're slang, right?
Yeah, so if you can turn something around and give it a secondary meaning. So let's say maybe that shirt was a design that was way different than anything else, and they named it something. They named it a certain design or something. I'm trying to think of a good example to make this, but if it were a design that now became a second meaning or had a second meaning to it, then it could possibly be trademarked. So I can't think of a good example. I'll have to think about that and see what I can come up with for next week.
Okay.
Ethical considerations are subject to personal standards. So what one person may consider ethical to another may be considered unethical. So how do we know what's right and wrong from an ethical standpoint? There's 5 major theories of ethics that help guide us. There's the ethical fundamentalism, and that says that a person looks to an outside source for ethical rules or commands. This could be from a book, or maybe in the book case, like a Bible. It could be a person, like someone that you look up to. But again, there's interpretations that may be different from others when reading a book or listening to the person you admire. For example, I mean, look at how many religions there are based on a book, right? And it's just a different interpretation of that book, that same book. So there are different ways that people look at things. And so it's really hard to determine what's right and what's wrong based on that. Utilitarianism, it dictates that people must choose the action or follow the rule that provides the greatest good to society. Of course, this has room for interpretation as well. Some people believe that this method requires mathematical calculation for good, and it's not very practical because a mathematical calculation is not very practical in an imperfect world, right? Kantian ethics says that people owe moral duties that are based on universal rules, such as the categorically imperative, do unto others as you would have them do unto you. So basically it requires consistency and reversibility. So you have to be consistent in what you do, and it has to be able to come back on you. Again, this would be up to interpretation based on how you would want to be treated. So how I want to be treated might be different than how someone else wants to be treated. And so my treatment of others in that case would be different than someone else's. There's Rawls, sorry, can't speak. Social justice theory, which asserts that fairness is the essence of justice. The theory proffers that each person is presumed to have entered into a social contract with all others in society to obey moral rules that are necessary for people to live in peace and harmony. Again, interpretation. Ethical relativism holds that individuals must decide what is ethical based on their own feelings about what is right and wrong. This one is definitely open up to interpretation and does not really offer any universal rules unless those people just happen to feel exactly the same. Let's see, page. Let's look at the critical legal thinking case, whistleblower statute, United States ex-rel estate of George Kudo versus Bear Corporation. In my book, it's 189. Okay. 156. Is that this one? So the Bear Corporation, what was that?
Oh, it's 157.
157. Okay, thank you. So the Bear Corporation is a large pharmaceutical company that produces prescription drugs, including its patented antibiotic Cipro. Bear sold Cipro to private health providers and hospitals, including Kaiser Permanente Medical Care Program, the largest health maintenance organization in the United States, and Bear also sold Cipro to the federal government's Medicaid program, which provides medical insurance to the poor. Federal law contains a best price rule that prohibits a company that sells a drug to Medicaid from charging Medicaid at a price higher than the lowest price for which it sells the drug to private buyers. Bear's executives came up with a plan whereby Bear would put a private label on its Cipro and not call it Cipro, and sell the antibiotic to Kaiser at 40% discount. Bear continued to charge Medicaid the full price. One of Bear's executives who negotiated this deal with Kaiser was George Kudo, a corporate account manager. Everything went well for Bear until Kudo attended a mandatory ethics training class at Bear. Later that day, Kudo attended a staff meeting at which it was disclosed that Bayer kept $97 million from Medicaid by using the discounted private labeling program for Kaiser and other healthcare companies. When he received no response to his memo, Kudo contacted a lawyer. Kudo filed a quitam lawsuit under the Federal False Claims Act, also known as the Whistleblower Statute, which permits private parties to sue companies for fraud on behalf of the government. The whistleblower can be awarded up to 25% of the amount recovered on behalf of the federal government, even if the informer has been a co-conspirator in perpetrating the fraud. After the case was filed, the U.S. Department of Justice took over the case as allowed by law and filed criminal and civil charges against Bayer. Bayer pleaded guilty to 1 criminal felony and agreed to pay federal and state governments $257 million to settle the civil and criminal cases. Kudo died, age 39, died of pancreatic cancer 3 months prior to the settlement. He was awarded $34 million, which went to his 3 children. So do you think the managers at Bayer obeyed the letter of the law?
Well,
no, he was a manager, right? And he was doing something a little shady there. Did the managers at Bayer obey the spirit of the law?
I don't think so.
No. And did Kudo act ethically in this case?
Yes.
So by whistleblowing, possibly, but he was one of the ones that actually negotiated the deal. So in that case, no, he was acting unethically. But it seems that he didn't know that that was unethical, apparently, because it was fine until he went to an ethics training class, right?
Yeah.
So should Kudo have benefited from his own alleged illegal conduct?
One smart man.
He definitely took advantage of the system, didn't he?
Right.
Oh, yeah. In my opinion, he shouldn't have got a penny, but he did come forward and it could have been a lot worse, I guess. So
yeah, there could have been many companies after that would have gotten screwed. So
yeah, well, and I think it's kind of crazy too that they kept 97 million from Medicaid and they agreed to pay 257 million. So this little thing cost them quite a bit of money.
Oh yeah.
All right.
Was that circumstance special because it involved Medicaid, which is owned by the government? Like if they had been selling the same product to like another private company at a different price, would they still have been in trouble?
Possibly, depending on the situation with that company. So in this case, the federal law contains a best price rule that prohibits a company that sells a drug to Medicaid from charging Medicaid a price higher than the lowest price for which it sells the drug. So that's where it got them. If it would have been another company, they may or may not have that type of situation. So it would be, I mean, I don't know about you. I do have prescriptions that I have to go pick up all the time, and it depending on where they get it from, because I've got it on there so that it'll actually do generics too. But depending on where I get it from, it can range from, it's crazy the amount of range that it has. Like it can be $30 one time and it can be $150 the next. It's just insane. So that's definitely when you come to the drug thing, it's kind of crazy. But let's see. So businesses are required to act with social responsibility. So in other words, they're required to act with awareness of the consequences and that impact their decisions, and impact that their decisions will have on others. So basically, they should have known that the impact on those Medicare patients would be crazy, right? So here's another situation where that business comes into a bad situation. So the there's 4 theories of social responsibility of a business, and the first one is maximize profits. And that says that a corporation owes a duty to take action that maximizes profits for their shareholders. The next one is moral minimum, that says the corporation's duty is to make a profit while avoiding causing harm to others. Stakeholder interest says a corporation must consider the effects of its actions have on persons other than its shareholders. And corporate citizenship says that a business has the ability to do good, or the responsibility to do good. And that means they're expected to give back to society, give back to the society that's giving to them. So I'm not talking about putting a bench in front of a store in case someone gets tired. I'm talking about like on a larger level. So the example in the book is that the business has a social responsibility to subsidize schools and help educate children. So it's a little bit bigger than that. So what do you think about the corporate citizenship theory? Do you think that adhering to this theory could hurt a business? So if they were expected to give all this, it could really be detrimental to them, depending on what requirements that they had, and who's telling them what they have to do, who's telling them that society needs this and you have to provide this. So in those cases, it can get a little crazy.
Who tells them that they have to do that?
So that's just a theory. That's just
oh, okay.
They're required to act with social responsibility, but the theory, those are some theories. Just like we had the theories of ethics that help us understand what ethics are. They help direct us. But honestly, if you took just one theory and only adhered to one theory, it would be very difficult because they're all up to interpretation. And according to this, so is the theories of social responsibility. It's open to interpretation, because who's to say that the bench in front of the store in case someone gets tired isn't social responsibility, right? It's not, I mean, corporate citizenship. So in that case, maybe that's all that's required instead of educating all the children, right?
Okay.
So all right, we're going to talk about okay. So in your books, there is an ethics case that says Bernie Madoff steals billions of dollars in fraudulent investment scheme. So basically on this one, do you all know who Bernie Madoff is? Did you guys hear about this? I mean, it wasn't too long ago. Yeah. This is a huge case and it really changed a lot of things. So one of the largest fraudulent investment schemes was run by Bernie Madoff over a 20-year period. Over the years, Madoff enticed investors to invest billions of dollars with him. The classic promise of extraordinary returns. Madoff joined the country club, served on board of directors of charitable organizations and universities, and traveled in high and wealthy circles. Madoff did not invest his clients' money as promised. When investors requested their money back, he paid them out of new money that he had raised from other investors. And he did that over 20 years. Can you believe that? Wow. Madoff used, that's just crazy.
I can.
So Madoff used much of the money to pay for his and his family's lavish lifestyle. Madoff and his wife Ruth had a Manhattan penthouse, a beachfront mansion in the Hamptons on Long Island, and a villa on the French Riviera. He owned 3 yachts, and Ruth had jewelry worth millions of dollars. Madoff was able to run his pyramid scheme for 2 decades without getting caught. However, in 2008, after a recession that hit the United States and the stock market plummeted, investors tried to recover billions of dollars of their investments from Madoff. He could no longer keep his fraud afloat and was arrested by the FBI In 2009, Madoff appeared in federal court and pleaded guilty to securities fraud, wire fraud, mail fraud, money laundering, and perjury for filing false documents with the SEC. The U.S. District Court judge called Madoff's fraud unprecedented and staggering. The sentenced Madoff to 150 years in prison without the possibility of parole. The judge stated, "Here, the message must be sent that Mr. Madoff's crimes were extraordinarily evil." Madoff, age 71, was committed to a federal prison. As part of his sentencing, Madoff was ordered to pay $170 billion in restitution. But of course, only a small amount of that will be recovered. Many investors lost their life savings. So do you think that Bernie Madoff acted ethically?
No.
No.
No, absolutely not. Did he act illegally?
Yes.
Yes. Are the investors to blame for their own misfortune?
No.
No. No, I mean, it's
They have done research though on like who they were actually doing.
Oh yeah, how are they not to blame? Sorry to cut you off. But, like, this is definitely their fault for not checking in like on who this guy is and stuff.
Yeah, absolutely. You should do your research. So yeah, they could be partially to blame, but they, you know, maybe they did do their research. Maybe, and it doesn't say this in there, so I'm not sure, but maybe there was a
Word of mouth.
situation where he was able to fraudulently, because it was like mail fraud and wire fraud and all that, maybe he was able to create some sort of profile for himself that made himself look really good. So yeah. Why do fraudulent investment schemes keep working?
Because people aren't smart enough to research what they're doing with their monies.
Yes, we're gullible, right? We have the
Trustworthy.
tendency to believe something. You know, if someone's likable, we have the tendency to just believe them and not question their motives or whatever.
Well,
so
and
ahead.
not to mention that he was living lavishly.
Yeah, right. Yeah.
He was painting the picture.
Well, I just want to say that he also like did a lot to cover up what he was doing, and he was given a certain amount of return on the investments and did take certain amount of fees. So to a lot of people for a long time, he was really well respected and they had no idea what he was doing. And he even like fooled the SEC when they came and like investigated him for annual checkups. So I posted like a podcast about it, and I listened to it a few years ago, and it's kind of long, but he really did fool people, and I really think that the people involved weren't being gullible, that he was very malicious.
Yeah,
absolutely. So let's now talk about the Sarbanes-Oxley Act, which requires public companies to adopt a code of ethics. In the late 1990s and early 2000s, many large corporations in the United States were found to have engaged in massive financial frauds. Wonder who that was. I'm just kidding. Many of these frauds were perpetrated by chief executive officers and other senior officers of the companies. Financial officers, such as chief financial officers and controllers, were also found to have been instrumental in committing these frauds. In response, Congress enacted the Sarbanes-Oxley Act of 2002, which makes certain conduct illegal and establishes criminal penalties for violations. In addition, the Sarbanes-Oxley Act promotes companies to encourage senior officers of public companies to act ethically in their dealings with shareholders, employees, and other constituents. Section 406 of the Sarbanes-Oxley Act requires a public company to disclose whether it has adopted a code of ethics for senior financial officers, including its principal financial officer and principal accounting officer. In response, public companies have adopted code of ethics for their senior financial officers. Many public companies have voluntarily included all officer and employees in the coverage of their code of ethics. So let's look at Exhibit 8.2 in my book on page 195. This is Big Cheese Corporation's Code of Ethics. So this is kind of an idea of what a code of ethics might look like. And basically it's just saying that the company has required their employees to adhere to certain actions, like acting with honesty and integrity, avoiding actual or apparent conflicts of interest in their personal and professional relationships, provide stakeholders with information that is accurate, fair, complete, timely, objective, relevant, and understandable, including in our filings and with other submissions to the US SEC and the Securities and Exchange Commission, and so on and so forth. There's a lot in here, and it's actually a pretty good one. So how effective do you think a code of ethics would be in preventing unethical conduct? So this could be, it could help a lot because it is outlining exactly how the company thinks that a person should act. And if they don't have that outline, it's not that they won't necessarily act that way, but they don't have that explanation of how they're expected to act. So it could actually help a lot. And it's outlining the ethical, what they feel is ethical as opposed to unethical. And that helps also because remember we talked about how ethics is kind of up to interpretation in some cases. So does anybody have any examples of a case you've heard of or a situation that you've heard of that the public officers of a public company were unethical? Yeah, for sure. So there's hundreds of them out there, or thousands even maybe. And especially before the Sarbanes-Oxley Act, there were quite a few, and that's why this act came up. And it's way more in depth than that. That's just a little piece of the Sarbanes-Oxley Act. And it's the piece that really corresponds with this course. So.
What about that guy, the subway guy? Would that be something? Wasn't he like involved in like, I don't know, like didn't he have like child pornography or something weird like that? I don't remember. Exactly.
Oh, I'm not sure about that one. So this is, oh, sorry, go ahead.
I was just wondering if that would be something that would be like unethical, like as far as what he did, you know?
Oh, and I'm not sure exactly what case you're referring to, so maybe I haven't heard about that one, but it could definitely be unethical.
The Wolf of Wall Street.
Oh, okay. So yeah, there's a lot of unethical acts out there. Sorry, I didn't pick up on the Wolf of Wall Street thing there. Sorry, Rihanna. Okay, so we are almost out of time, guys. So I wanted to go ahead and talk to you about your assignment for a little bit before we get done with class. So was everybody able to access the assignment in Canvas?
I haven't gone in to look at it yet, but I have access to assignments, yeah.
Okay. All right.
It just shows the case, right?
Yeah, so it's just the
Just the
case
name of
and
it.
then the rubric. So it shows you that the case in this, so, okay, so those of you that didn't hear me say this last week, I just want to make sure that I'm clear. So my book is a little bit different than yours. And so the cases in the back of the book, although they're the same, they're numbered differently. So what I did is I wrote down what the case is. So in this case, in my book, it's 8.6, but in your book, I think it's 8.4. But it's the McDonald's or Bradley versus McDonald's Corporation. So if you look
Page
at the bottom of
166.
166?
Yes.
Okay, so page 166. And if you look at the very bottom of that case, you'll see it says Bradley versus McDonald's Corporation. And so that's the one I'm talking about. So make sure you do the correct one, even if it doesn't say 8.4, it's whichever one says Bradley versus McDonald's Corporation.
Do you know which page that is on your book?
In my book, it's 199. And it's ethics case 8.6 in my book. And it starts out, McDonald's Corporation operates the largest fast food restaurant chain in the United States and the world. That's the first sentence of that case.
So these cases
Yeah, it's at the bottom of, sorry. It's at the bottom.
Oh, sorry, can you just say one more time what page it is for you? I have your book as well.
Sure, it's on page 199.
Okay.
And in my book, it's ethics case 8.6.
Gotcha. Thank you.
You're welcome.
Hey, Cindy, sorry to interrupt you again. So for the homework, for the cited sources, do you want us to like cite something similar to this case? Like, you know, we have to find another case that's similar to it, or do you want us to, you expand on that a little bit?
Yes, absolutely. So I'm going to go over the rubric. So the rubric in there actually tells you what I'm looking for. And the first thing says that the legal issue and conclusion is stated. So what I'm looking for there is that you define the legal issue of the case. So you're going to read the case and you're going to go, okay, this is the issue, and you're going to define the issue. An example of this would be in the cases that we've read in a case. Let's just look at, so there's cases in your chapter. So like case 8.1, we read that one with the Walmart stores versus Samara Brothers, Inc. And there's a place in there that says issue, and it actually talks about the actual legal issue in the case that's brought up in the case. So that's what you're doing. So you're going to research the case and explain the conclusion. So you define the legal issue, then research the case and explain the conclusion. And then you're going to answer any questions. So in this case, the ethics case does not, oh yes, it does. So it has questions. It says, has the plaintiff stated a valid case against McDonald's for deceptive and unfair acts and practices in violation of the New York Consumer Protection Act? Does McDonald's act ethically in selling products that it knows cause obesity? Should McDonald's have disclosed the information regarding heavy users? So those are the questions that you would be answering in this. The next one is your opinion. So you're going to talk about the case, how you felt, how it made you feel, and how do you feel about it? What is your opinion of the case? And you would give your opinion, and you would support your opinion with two-cited sources. So we talked about that a little bit last time. And what I mean by that is you can use your book. You can go back in your book and find something that supports your opinion. You can use the internet and find an article on the internet that supports your opinion. You know, whatever your opinion may be. And it's your opinion. It's not wrong. I just want support for your opinion. So the cited sources, there's nothing that I require as far as how you cite them. Like you don't have to use like MLA or APA or whatever format. I just need you to tell me the source. So you're gonna, if you quote it directly, obviously you're gonna do what you're supposed to do with that and put it in parentheses or whatever. But at the end, I just want you to say, just give me a link to the source. So either a link, if it's an online article, or just cite the book or whatever it is, but just make sure you give me a good citation there. Make sure you use correct grammar, punctuation, and spelling, word, and a lot of the other document type software have spelling, grammar, and punctuation help. So I'm looking for that. And then I'm only looking for one page. There's a lot of students in this class. It's a lot for me to grade. So I'm looking to keep it a little bit lighter. So use Times New Roman 12-point font, double spaced, and the completed assignment should be about 1 page. Am I going to be upset if you go a little over 1 page? Probably not. Let's just try and keep it reined into, a page. Each one of those things is worth 4 points to give you a total of 20 points for this
Like a
assignment.
header or something.
What was that?
You want like a header or something, like a title or.
No, please make sure you put your name on the paper. But other than that, you don't necessarily, you could put the case, ethics case, Bradley versus McDonald's on there, and that would be good enough. Just something that, so that if I'm grading, if I've got extra like assignments or something and I'm grading them, I know exactly which one you're pulling from.
Okay.
And as far as citations go, if we need to use them, would you prefer if we used MLA or APA format?
I'm not picky, honestly. And I'm a very informal person when it comes to paper. I'm not going to be, so I'm more from a business mind, and a business mind is basically, let's just get that done. So as far as I know, that's hard. And if you do APA or MLA or whatever you're used to, and you quote it just perfectly, I'm fine with that too. But if you just put the link to the article or something like that, as long as it's quoted in there that that's coming from somewhere else, I'm fine with that. And there's got to be two-sided sources in there.
Sounds good to me. Thank you.
You're welcome.
Did you say these cases you can find them in 2 sections, or is it just in the back of the book? That's what I was going to try to ask.
So the case that you're going to be working on, the ethics case, the McDonald's Corporation case, it's just in the back of that chapter. So this is chapter 8. In the back of chapter 8 is the ethics case. So it's only right there. Is that what you were asking, Rihanna?
Yeah, just because my book doesn't have the headings, how you like named it. You said like McDonald's versus something like.
Yeah, so that's at the bottom. So it's at the very last line.
Oh, okay. Gotcha. Cool. Thank you.
Okay. Yeah, you're welcome. So that's where I'm identifying it. So that's actually the case information.
Got it. Thanks.
You're welcome. All right. Any other questions about the assignment?
One more.
Okay.
Just to confirm, we just have to use citations to like help our opinion or defend our opinion, basically.
Right. Yes. Something that you know that. So you're going to basically give your opinion, and then you're going to say, and this is why I think this, or and here is a support is supporting of my opinion, or something to that effect. So whether it be that your opinion is and this doesn't have anything to do with this case, so honestly don't use this, but let's say that it was a case about murder or something, and you use something from the book about murder. You could do that. You could absolutely do that, and you could just quote the book, but that would only be one source. So then I want you to go out and find something else about it that supports your opinion. Does that make sense?
Yeah, that makes sense.
Perfect.
And I did also want to make a comment about the Target thing you were talking about earlier, since I do work at Target.
Oh, okay.
Yeah. Like I just remember that the whole store kind of just like shut down. All of our systems just went blank, and it was a fun day. So
I can imagine it had to be really crazy.
it was.
Yeah, and the fact that they shut it down right when they did, it actually helped mitigate the damages, because they were able to, from what I heard anyway, they were able to, they identify that someone was hacking their system, and then they were able to get it down right away so that it did less damage than it would have if they would have left it up. So that's good. All right. So this assignment is due by 5:30 p.m. next Wednesday. So at the start of our class, it's due. Right? Is that what I put on there?
That's what you have.
Yeah, January 27th at 5:30 p.m. So that's when it's due. So so you'll need to put this one in. And we do have an assignment next week as well. assignment 2 will be next week. So this will be a good opportunity. Next class will be a good opportunity. If when you were digging into this assignment, you had some questions, it'll be a good opportunity for you to ask those before we do the next assignment. I'll get those graded as quickly as I can afterwards. So it'll probably be a couple of days after, after our class on Wednesday. So hopefully you'll get something by the weekend so that you can see before you get too far in your second assignment. So if you need to know if you need to kind of change direction a little bit. All right, any other questions? Okay, so that's all I have for class tonight, and I will see you next week.
Thank you.
Thank you.
Have a good one.
Thank you. Have a good night.
Bye. Thank you.
Good night.